Hiya, welcome back to another fun-filled episode of Law and Ethics, the recap. So we've talked about the assessments, we've talked about the basics of law, we've talked about the courts and how they're structured, and we've talked about contempt of court. These are all really important topics. Arguably one of the most important topics from our point of view as journalists is defamation, because it's the one where it can land us in an awful lot of trouble, and very expensive trouble as well. So I want us to talk about that. I know you've been talking with Sarah about defamation over the past few weeks. So I'm just going to remind you about what the legislation is, i.e. what the name of the law is, what the key definitions are, and what the key defences are. Sarah may have touched on this example, but it is a useful example of Max Mosley, who's the formerly the boss of Formula One, and interestingly the son of Oswald Mosley, who was a famous fascist in Britain some decades ago. But he was the subject of a News of the World front page back in 2008, which said F1 boss has sick Nazi orgy with 5 hookers. And it's led to a series of other follow-ups. You can see what other newspapers did all about him: the Liar, the Swish, and the Whore Probe. So very, very damning stuff. And then the Mail as well, getting stuck in, looking at how Max Mosley had been frozen out by the Labour Party. So lots of very damaging reports. In the end, he fought back. He sued the News of the World and other newspapers about this headline. And what's particularly interesting is that he didn't deny that he had been having an orgy with 5 prostitutes. That wasn't what he challenged them on. He said that they couldn't justify the fact that they'd accused it of being a Nazi orgy. Now, the News of the World had pictures of Mosley, and the prostitutes he was with appeared to be wearing what they said looked like Nazi uniforms, and he said no, they were just fantasy role-play uniforms, but were not specifically Nazi uniforms. And that in the end the court agreed. So he won that case because the News of the World was not able to prove what they call the full sting of what they'd said. The court decided that an orgy with 5 prostitutes is one thing, but to say that it was a Nazi orgy is much more damaging. So it's a good example to show that you need to be absolutely clear on everything you say and the full sting of what you accuse someone of doing, and be aware of the full implications of the words you use, and be able to prove what you say, or have at least another defence to be able to use if you accuse something of doing something which damages their reputation. So remember, we're structuring our thoughts. So we're going to name legislation, we're going to look at the basic definitions, and we're going to look at the defences for defamation. So the legislation, key piece of legislation from our point of view, is the Defamation Act 2013. There is also the Defamation Act 1996, and the 2013 Act updated the 1996 Act. So they're both still in existence. The most recent one is the Defamation Act 2013, which updated the 1996 Defamation Act. So moving on to key definitions. So what is defamation? You just need to be really clear on what defamation is. So it comes down to a list of things that your words might potentially do. So do you expose a person to hatred, ridicule, or contempt? If you do, then potentially that is defamatory. Could your words cause, or the information you publish, cause someone to be shunned or avoided? If so, potentially that's defamatory. Does it lower a person in the estimation of a right-thinking member of society generally? If so, potentially defamatory. Or are you disparaging a person in their business, trade, or profession? Are you saying that someone is not very good at what they get paid to do? If so, it's potentially defamatory. The key thing, the key measure which the courts have to decide upon is whether the information you've published or broadcast causes serious harm. That's a key phrase, serious harm. It can't just be a little bit of harm to someone's reputation. You have to show that it's caused serious harm to your reputation, in which case that passes the test to be defamatory. So the claimant is the person who is complaining that their reputation has been damaged. So they have to prove that the words are defamatory. So we've just looked at the definition of that. So have those that material caused or is likely to cause serious harm, and there's that phrase again, serious harm to their reputation. If it does, then it's defamatory. They also need to show that what you have broadcast or published it could be reasonably understood to refer to them. So obviously if you've named them and photographed them, then it clearly identifies them, and it would be reasonably understood to refer to them. But it is possible to potentially identify somebody without naming them. So if there were a football team, let's go for a football team. If we said one member of this football team is a crook, the whole football team, all 11 people who are actually on the pitch, let's ignore the subs bench, all 11 of those people could say, well, there's not very many of us, so a lot of people might assume that it's me, and so they could all 11 of them could sue for defamation, saying that the person seeing that information could reasonably identify them or could reasonably understand that it refers to them. However, if you said a member of the crowd at the football match was a crook, that group would be too big, because a member of that crowd couldn't say, well, another person could reasonably identify me, because there's too many of them. So a sort of working number, there's no specific number set in law, but 12-ish is about the cut-off point for a group where you could be reasonably identified as a statement relating to you as an individual. And the third thing the claimant needs to prove is that the material was published to a third person. That doesn't mean it has to have been printed on the front page of a newspaper or broadcast on 10 o'clock news. You could just say it to another person, write it to one other person, as long as it's been published to one other person other than you, the person whose reputation or is claiming that your reputation has been damaged, and the person who's actually saying it. As long as one other person has been given that information, then you can prove that it's been published. And those are the key things, and you need to remember those. DIP, defamatory, identified and published. That's the conditions that need to exist for a defamation action to take place. So DIP, and that's for the crucial definitions. It's a useful little acronym, DIP, to remember what needs to exist in order for a defamation action to happen. So moving on to the defences. Remember we've got those basic definitions now. We know what the law is. Defamation Act 2013, which updated the Defamation Act of 1996. Got those key definitions about causing serious harm to somebody's reputation, that something's been that the material identifies someone and that it was published. So the main defences which we rely on as journalists are those at the top there. So we have truth, honest opinion, qualified privilege, absolute privilege, and innocent dissemination. So those are 5 key defences. There are other defences available, things like public interest, accord and satisfaction, offer of amends, and leave and licence. So we won't go into some very much detail on those additional defences, but let's run through these main defences to be going on with. So truth. So that's when we say our defence is that what we have said is actually true. But you'll see with the Max Mosley example I gave you, you have to prove the full sting. So saying that Max Mosley was having an orgy with prostitutes was not, it wasn't enough to just prove that. They had to prove, the News of the World had to prove their use of the word Nazi. They had to prove that the prostitutes were dressed as Nazis, and they couldn't do that. All they could do was prove that they were dressed in prison-style uniforms. Is how it was put. You need to prove that it was true on the balance of probabilities. That's useful for us. It's always hard to prove an absolute truth, but the law demands that we prove that something that we've said is true on the balance of probabilities. Because remember, this is civil law. This is not criminal law we're into now in defamation. This is a dispute between two individuals, between an individual and a newspaper in the Max Mosley example. So we're in civil law, so it means it's true on the balance of probabilities. And it's really useful, a truth defense, for things like investigations. If we go out, investigate something, gather all the evidence together, and have that evidence to support the report, the article which we publish, or the story we publish, we should have nothing to fear if we have done our research well, and we've gathered all the evidence to back up everything that we've reported. The next key defense is honest opinion. So this protects opinions, and it's particularly useful for things like reviews and opinion columns, because it's okay to express your opinion or your review as long as fundamentally it's an honestly held opinion. So you can't just make up an opinion simply to shock or to get an audience. It has to be an honestly held opinion. It needs to be recognizable as opinion, so you can't present it as fact. You have to present it as opinion, and you have to also make sure that it's based on fact. So if you write a gig review and you say that the band was rubbish, but it turns out that you actually weren't there, then you would not be able to use an honest opinion defense, because you were not there. So it cannot be based on fact, and it cannot be your honestly held opinion, because you were not there. So honest opinion, very useful for opinion pieces and reviews. So the next really important defense is a very important one on a day-to-day basis for journalists, is privilege. And this splits down into absolute privilege and qualified privilege. And you'll see that qualified privilege itself then subdivides into part 1, where you have to give a right of reply, and part 2, where you do not have to give a right of reply. So just running through those. So absolute privilege. This, in practical terms, from our point of view as reporters, this really relates to our reporting of court proceedings. So we get absolute privilege. So there's no challenge to a defence of absolute privilege. It doesn't matter whether what we're saying is true or whatever. It's as long as it's based on a situation which attracts absolute privilege, then we're okay. And that those occasions are fair, accurate, and contemporaneous reports of judicial proceedings. So if we're reporting on a court case and we're providing a fair, accurate, and contemporaneous report of that court case, then we have an absolute defence, absolute privilege. We're allowed to say it. Do you remember this? This is one of those rights which underpins our right to freedom of speech and underpins open justice. And you'll notice that it looks very similar to one of the defences available for contempt of court. Fair, accurate, and contemporaneous report of judicial proceedings. So make sure you keep those two things distinct in your mind. So defamation and contempt are very different things, but the word contemporaneous means the same thing. So it's about publishing at your next opportunity. The next time you have an opportunity to publish something, you need to put it in there. You can't just keep hold of it for ages and ages and then publish it when you choose. So absolute privilege really, from our point of view, really applies only to reporting court cases. MPs get absolute privilege for what they say in Parliament. However, we do not get absolute privilege for reporting what they said in Parliament. What we get is qualified privilege. So this is the other kind of privilege. So this is a fair and accurate report without malice. That's important. So we can't have any malice, any grudge involved in what we're reporting of parliamentary, judicial proceedings, press conferences, or public meetings. So you'll see the difference there is that with qualified privilege, we cannot have malice. Doesn't matter with absolute privilege. Doesn't matter if we're doing it maliciously. We're allowed to. we have a defence. Under qualified privilege, no malice is allowed, and you'll notice that the word contemporaneous has disappeared, so it means that we can publish it at any point. So this applies to a whole range of broader events, so things like council meetings, press conferences, public meetings, things like that. So qualified privilege is probably the one that applies to most of what we do as day-to-day reporters. You remember I mentioned just now when I introduced the idea of privilege that there are two types of qualified privilege. It's part one, which is not subject to an explanation or contradiction. So there's no automatic right of reply if it's material which is regarded as being included under part one. So that's information issued by the government, for instance, or by a government department. Part two is subject to explanation or contradiction, so there is a right of reply. So if there's a press conference and somebody says something in that press conference, we have a right to publish that. We have a defence under qualified privilege to publish what was said at a press conference or a public meeting, but as long as we give the person whose reputation is potentially being damaged, we give them a right of reply. So absolute privilege, mainly for court cases from our point of view, and then you have qualified privilege for other issues like public meetings, council meetings, press conferences, etc. But you need to know whether it's a part one, in which case you don't need to get a right of reply, or part two, when you do need to get a right of reply. It's always good practice to get to give the right of reply, whether you have to or not, because you want to get balance in your stories, but the law only requires it for certain types of material like press conferences. The next area of defence is innocent dissemination, and this includes material you might publish during live broadcasts when things might not be as controlled as you want, or for things like online comments. As we all know, comments can include all sorts of things. So the key points about the defence of innocent dissemination is that there should be no pre-moderation or editing of comments. So if we pre-moderate, if we check things beforehand, we're accepting responsibility for them. So the safest way for things like comments is not to moderate comments before they're published. And the other key point is that you should always act as soon as you know there's a problem. So whether that's a comment that you've been published online, or whether that's a live comment that's been made during a live broadcast, as soon as you know that there's a problem and something has been said which is potentially defamatory, you need to take action. You need to take that down. You need to apologise. You need to recognise that there's an issue. You can't just ignore it. If you ignore it and let it just continue to stay out there, then you can end up in a lot of trouble. So those are the key points, but innocent dissemination is enshrined under Section 1 of the 1996 Defamation Act. The 2013 Defamation Act strengthened that under Section 10 and basically made it very clear that you have protection as long as there's been no pre-publication moderation, and that you have taken reasonable care. So if you've taken reasonable care and you take quick action when there's a problem, when a potentially defamatory statement is made, you have a good defence under Section 1 and Section 10. If you ignore complaints, or if you haven't taken reasonable care in the preparation of that story or that broadcast, then you can be in trouble. There are other defences. Have a read about those in McNay's rather than me getting too bogged down. But the point is, there are defences for innocently disseminating what someone else has said, but only if you cannot be shown to have been aware of it before it went out. I mentioned there are other defences for defamation, so public interest, accord and satisfaction, offer of amends, and leave and license. So have a little look at those in your reading in McNay's, because they're important defences, but I don't want to get too sidetracked by those now. So that's defamation. So we've covered all of the basics of what we've been through up so far for this module. Remember to think about this structure for the way you think about the law. What's the name of the legislation? what's the definition of the offence that's being involved, and what are the defences available to us, what are the key defences. Make sure you know about those defences, because that's how we operate as journalists, is always being aware of the defences so we can operate effectively as journalists. You need to go back and look at the reading. So for this week, go back over all the previous lecture slides and read all the McNae's chapters if you haven't done that already. For next week, we're going to be talking about privacy. I believe Debbie Manley is going to be with you for a video lecture on privacy. Then for next week, have a look at McNae's at chapters 26, 27 and 28, all about privacy. Otherwise, I will see you at the workshop on Thursday, and we'll be going back over some of this recap and looking at some more sample exam questions. Thanks for your attention, and goodbye.